gender role.
This meeting is being recorded.
Start again, Deborah.
Not again. My name is Deborah Kane, and I'm co-chair of the Gender Roles OLLI SIG Shared Interest Group, which studies issues connected to women and to LGBTQ. We meet monthly every Wednesday of the year, and we welcome new members. We started about 7 years ago with 3 members, and we're now up to about 25 members, all eager and interested in these issues, and we study them and share emails and share media content with each other regularly. This webinar is serving for over 500 members of OLLI at this moment. So we're happy to welcome everybody. When we sponsored a course on the Equal Rights Amendment about 4 years ago, I invited Professor Tom Gerety, to give us a lecture on the constitutional issues connected with the ERA, and he did. It was a wonderful lecture, and I never forgot it, and we established a relationship ever since. He still helps us with the gender SIG from time to time, never fails us if I ask him a question or to come to talk to us about serious matters that are disturbing. So as soon as I heard and saw in the media the leak of the Alito memo, I thought immediately, oh my God, what is going to happen to Roe versus Wade, even though it was not strictly speaking a surprise, because we had been discussing some of the views of Linda Greenhouse on our SIG. Nevertheless, it was a horrible shock. And I immediately thought of our dear friend, Tom Gerety. Can he really help us with his advice and his perspectives on how we go forward at this moment? So I'm very happy to welcome Tom. And for those of you who do not know him familiarly like we do as Tom, Professor Gerety is the former head of the Brennan Center and retired collegiate professor of law and humanities at New York University. So we're very happy that Tom retired to the Berkshires a few years ago and is making himself and all his wisdom and learning available to OLLI. And with that to do, the last thing I want to mention is the format for today. We in the SIG have been forwarding to him our various frantic questions about the future of Roe v. Wade. And Tom will be answering or incorporating those questions from us in the SIG in his talk. After those questions are finished, or he is finished with that matter, you will then be able to put your questions in the chat, and Ellen Crobier will be taking them out of the chat and will read them aloud. And with that, I get out of this picture, I hope, and turn it over to Tom.
Ellen, are you going to say something, or are we off to the races?
I think we're off to the races, Tom.
Okay. Let me start by saying that as a man and a person, who cares about these issues, but clearly I care in a different way from those of you who are women and have or might bear children, that I come at this with a sense of real almost intimidation or humility about what I can offer as somebody who studied constitutional law for a long time. This exchange and talk, I hope, will be one in which a lot of you have concerns, questions, and comments, as the perhaps 7 or 8 that I have already have come forward. I think all of us had a sense that this draft opinion from February, so already 2.5 or 3 months back, was likely to be the result of the hearing on the Mississippi case the Dobbs case, the 15 weeks case as originally filed, which would have trimmed back Roe v. Wade and the Casey case, both from the point of viability to another point, 15 weeks, a somewhat arbitrarily chosen shorter period. But as most of you know, during the filings and at the argument on the Dobbs case, the Mississippi case, the Mississippi litigator, who is actually originally from California, their Solicitor General, changed the direction, and there was intervening, what you might call pending or legislation with pending efficacy at Mississippi and elsewhere, all of which was taking a view to what had happened on that Texas case. And we can go into that in a minute. But in any case, it changed the whole approach from 15 weeks to, no, we want to get rid of Roe v. Wade altogether. In other words, normally litigants would come forward before any court, Supreme or otherwise, with their filings and their legislation that's been challenged and defend that legislation as such, in this case, as 15 weeks, as the final point at which an abortion could be had under the Roe and Wade precedent and the other precedents. Instead, there was a kind of shifting ground underfoot, a kind of quicksand in which this all slid towards an argument about the very fundamental question. There's the famous Hemingway cliche about going bankrupt has been in all sorts of magazines and papers in the last couple of years. That, you know, how do you go bankrupt slowly at first and then all of a sudden? And I think many of us have felt that slowly the right to choose, the right to an abortion under Roe and Wade in the Casey case, which revised it, was being chipped away in many, many states, even as other states had relatively generous following of the precedent and the permission, if you will, or the constitutional right. But it seemed to me that it has all happened in such a way that many of us felt we're holding the line. Yes, there's been chipping away, but on the whole, this 50-year-old right is holding and is being trimmed. But of course, there was also that feeling in the pit of your conscience or your tummy that it might all go down in a hurry. And I think that is the look of it now. One of the questions that arises in everybody's mind and that many experts have commented on, and I'm not going into the leak for the moment and how important the leak is and so on. I think that's all arguably true and from one perspective or another, but it's trivial on the whole. What's going to happen is we're going to get a decision on the Mississippi legislation, and that's probably going to trigger a lot of massive changes in the United States. What I will say is that in the history of the modern history of the Supreme Court, it is extremely rare for a judge to vote, to participate in deliberations, to vote in deliberations, to recognize the senior justice is going to appoint someone to write. Usually that's the Chief Justice if the Chief Justice is in the majority, but if the Chief Justice dissents, it would be the senior justice, and presumptively in this case, that's Clarence Thomas, the senior justice in terms of tenure on the court. Just to repeat that, typically if the Chief Justice is in the majority, he takes the case or assigns the case. If, however, the Chief Justice is a dissenter or in the minority, then the senior justice in the majority vote at the deliberation following argument assigns the case either to himself or to another. And most of us assume that Clarence Thomas assigned it to his very close partner in argument and right-wing positions on the court, Justice Alito. Well, having said that, I want to ask you all to right now, because there are a number of you, my experience of these Zoom things has been that there are really very few questions in the chat. And I do have, as Ellen and Ray and I said, several questions, or Deborah said, several questions going forward that I noted from correspondence I've had with Deborah and the members of this committee. But I would urge all of you to think about what your most important questions are and to put them in the chat so that Ellen Kriebier can synthesize them, if you will, and pass them on and we can all discuss them. I'm hoping that this will be a real interactive discussion rather than sort of me falling back on lecturing at you. Well, this has come, I think, for most people who are part of this conversation as a massive, massive blow and shock, albeit perhaps not a surprise. It is, I think, almost certainly going to hold as a majority decision. I think it's very unlikely that the Chief Justice, who seems to be the negotiator here, who's hesitant about the decision, and this is reading tea leaves, will be able to draw, say, Kavanaugh or Barrett out of the majority that wants to overrule Roe. Most of you who've had a chance to even glance at excerpts of the leaked February majority opinion recognize that its tone has that ferocity, that I'm almost tempted to say arrogance and scorn that we sometimes associated with Justice Scalia in the past. Some people have jokingly called Justice Alito Scalito to merge their personalities. It's a very, very strong opinion with lots of barbs that may be sanded off by countering drafts from others in this majority as we go along towards June. But I would not at all be surprised if the fundamental structure of it and its fundamental points remain very much as they are, and most importantly, that it's holding its actual conclusion of law, that Roe and Wade is no longer good law, and neither is good constitutional law, and neither is the Casey decision, which changed the burden to some extent and loosened some of the permissiveness towards the states to regulate, but nonetheless maintain the fundamental right in women to have an abortion up to some point in their pregnancy, whether viability or a looser standard that might bring it back to, say, 20 weeks or 22 weeks or some such thing. For most of you, I think there's not just shock, there's probably anger, outrage, indignation, and I think it raises the question, what hammers, if you will, what tools do people who oppose this likely result bring against what now looks like an inescapable result in constitutional law? And obviously, you bring reason and arguments, discussion, you bring your outrage and your anger, I hope. You bring your politics and your activism, your organizing. What's wrong with this decision to me, and now I will speak very personally, is not some simple details of its reasoning or the way it cites precedent or argues with scholarship. We can go into that in detail. What's wrong with it to me is that it brings forth the possibility and the enormous probability in half of the states or so that we're going to have an oppressive, intrusive, essentially heedless set of laws with relation to women, young women especially, poor women especially, and as is so often said on the news shows, women from minority or oppressed communities where poverty is rife and persistent and so on. This is going to produce some very brutal results. I think we all recognize that. There are going to be deaths, there are going to be injuries, there are going to be horrid prosecutions. There are going to be family, especially with this kind of Texas system that's now like an infection spreading to the other right-wing states. Right-wing legislatures, we're going to see bounties offered to people who challenge abortion. We're going to see campaigns to interpret the 14th Amendment in a wholly another way, in such a way that the personhood of the conceptus or the fetus is found to occur at any point in the pregnancy, but also at the point of conception. And then that may lead to efforts to criminalize any and all abortions, except perhaps for the health of the mother, depending on the state and so on. So this is going to be a massive change for our country. And you could say, well, it's a regional change in the South and the Midwest, and there's truth to that, but we all know there are going to be efforts to make it national through the court itself, through legislation that reaches beyond state boundaries to try to prosecute people who say travel for this, raising other constitutional questions we'll get to. This is a massive, massive change, and it's part and parcel, to put it bluntly, of the overall effort to have what some have called a minority rule democracy or a minority rule authoritarianism in the United States. Going further, it's part and parcel of a movement to have a kind of white supremacy interpretation of the Constitution, or a white Christian interpretation of the Constitution, a masculinist interpretation. I mean, you could put a lot of words on it. We all know we're facing, around the world really, but particularly in the United States, a populism that is hostile to immigrants, that sustains and rouses the ancient hostility to African Americans that led to and that sustained slavery over so much of our history and sustained Jim Crow and prejudice and racism thereafter. So this, to me, is a broad front in America's political struggles, and it's a threatening one. Some years ago, I gave a talk, I think my first talk to OLLI, in which I mentioned that I thought that Trump would be a stress test for the Constitution. I published an essay on that in the Berkshire Eagle. I think that was, as it turns out, many of you would say now, and I think I'd say myself, that was naive. It's not just a stress test. It's much more than that. It's a challenge to the fundamentals. And those challenges are now heightened, strengthened, more defiant and triumphalist than we might have thought they would be with Trump's defeat. And I think are threatening for the next decades. It's not going to be a short struggle or a quick reversal on this. And issues like the passage of the ERA possibly, and other changes, federal legislation to support the right to an abortion, state legislation similarly, as we see in so many of our states like Massachusetts and New York. All of these things are part of a much larger struggle. None of them, it seems to me, will be at all decisive, nor will medication abortion, given what's going to happen in these states in terms of prosecuting and persecuting people around that. Now, a question that arises here is, how bad is this court from this common point of view that I think most all of us share in relation to other past courts? And I was talking to my friend David Rudenstein, who teaches down at Cardozo Law School. And he was saying what I had thought too, and we were just going back and forth about the anti-New Deal court of the 30s, the court that Roosevelt threatened to pack, and that one justice switched, 3 later retired. You know, the court that was so changed by the New Deal because Roosevelt effectively, Franklin Delano Roosevelt effectively backed down the hard right justices on that court and forced them into retreat. And he lost the battle to pack the court. And have, in effect, a kind of retirement clause where he'd appoint a justice for everyone over a certain age. But he won the war. He had a real victory there because he may have lost that battle, but he won the war. And the one justice, Owen Roberts, switched, and the others retired and were gone very quickly. And then he had a court to his liking and a court that liked and supported social legislation of the sort that the New Deal represented. And so many of the institutions, Social Security and so on, that we have now are a product of that switch. That court is, I think, a very good comparison to this court. A retrograde Chief Justice, some very hard right anti-social legislation, anti-minimum wage, anti-maximum hours. They were anti a whole bunch of things, and would always say, oh, these are matters of liberty of contract under the Constitution, and sort of haul out an old-fashioned view of our Constitution, well, a really impossible view of our Constitution, to stop the states and the federal government from legislating to help people and to give them better wages and shorter hours and the possibility of retirement and all the rest. So that's one analogy, the anti-FDR court of his first term and a little bit of the second term, the 32 to 37 court. Another one is the anti-reconstruction court that came into full force in the late 1880s and 1890s, the court of Plessy and Ferguson, the court of Jim Crow, the court that really ripped some of the heart out of the 13th, 14th, and 15th Amendments, the Civil War amendments that eliminated slavery, that guaranteed citizenship to persons born in the United or naturalized in the United States, and that more importantly and more cogently here, that it's guaranteed equal protection to all persons in the United States and due process for their life and liberty. That court was a very reactionary and hard court too. And one of the questions that arises is how was that court greeted? That court held for quite a while until, I'd say, the progressive era and Teddy Roosevelt. But it reappeared in the 30s with Franklin Roosevelt and its force of thinking and its way of thinking. This court, I think, is in some ways unique, this right-wing majority on the court, these 6 votes, or 5 plus the chief, who's clearly very, very conservative, but in a somewhat more old-fashioned, your grandfather's or your father's Republican Party than the others. This court has on it, in ways that we can talk about, and we know how it happened, justices essentially to a person who grew up in a Republican Party and a Federalist society in the law schools that was trying very, very hard to groom young judges and ultimately young justices who were reared ideologically. It reminds me of Dianne Feinstein's comment in the Amy Coney Barrett hearings that the doctrine lives loud within you or sings loud in your soul or something. And much as Feinstein had to pay a price for that and was yelled at and shouted down for it, there's like, as with so many other political faux pas, there's a powerful truth in that. The doctrine lives very loudly in these 6 justices. They imbibed it and believed in it as college kids in just about every case. And they certainly espoused it and studied it in law school. They clerked and held career and pursued careers that followed this doctrine. They clerked for conservative judges and justices in most cases. They taught courses and wrote articles to this effect. And I think that it's, in that sense, unique and special. I don't think we've had judges who are ideologues, professional ideologues in this way before. And I think it bodes ill for those of us who hope for the kinds of mind-changing or gradually opening up to other possibilities that we saw in lots and lots of justices in the past, whether it was a Holmes opening himself up to freedom of speech and a sense that there was injustice there, or Stevens, who was a brilliant judge who came on as a Republican, then gradually became one of the reigning liberals, Souter, et cetera, et cetera. We've had a lot of justices who simply were not hard ideologues. They were pragmatists who may have come out of the conservative side of our politics, but who were very, very open to claims and causes and learning and understanding, and I think giving generous response to some of the concerns of prejudice, oppression, and so on in our legal systems and our economic system. The ideology, as you all know, has many names. It's perhaps its most simplest form is the simple opposition to a living constitution or an organic constitution. It's an ideology that says, no, the Constitution was fixed at a certain point in time, and we're going to stick with the way it was fixed. And we have some special insight into how it was fixed and what it meant at the time. One form of this, the most famous, is called originalism, because it's an ideology that claims to know or to be able to find out what the original intent was. There's a lot of what you might call potted or amateur history in this. A great example is the gun case, the Heller case, where a certain historical slant was said to be true in a kind of permanent sense that has now opened up our gun laws across the country, and it's about to be opened up further, we think, in the New York case that's before the Supreme Court, to a kind of vision of the Second Amendment as guaranteeing gun rights, not because we needed a well-armed militia, as it says in the first line of the Second Amendment, but because every individual has to have a right to hold guns. And then what kind of guns? Well, the kind of guns that are popular at the time, essentially. At this time, in other words, not the kind of blunderbusses and old-fashioned weak guns of the old days, but the modern newfangled guns of the sort that were used in Buffalo and so many other places in these horrid mass killings, many of which are killings of women, some of which, like in Buffalo, are racist killings, and some of which simply represent some kind of wild anti-government scheme like the Oklahoma City place. Not that all these ideologies don't mix together. So the first and most powerful ideological foundation offered by these right-wing judges is originalism. And what it means exactly, I think, is fairly loose, but you get the basic point. We're going back to the original intent, and we have special access or some kind of ability to do that, of which people like me are very skeptical. A second line here is textualism. We, say the right-wing justices, stick to the text and only the text. And sometimes this has astonishing effects. In the Title VII case on transitional sexuality, the funeral home director who changed from man to woman and then was fired, it was Justice Gorsuch who said, well, it says, on the basis of sex, you can't discriminate. Therefore, the text gives a liberal result that you can't discriminate against a trans person who's in your employ. But mostly textualism is used to limit the full purpose. An example of that is this very young and I think callow judge in Florida, Judge Mizell, who made the decision on the ambit of the CDC 2 weeks ago, namely saying that, well, their ability to fight disease does not only includes things like sanitation, cleaning up, and so on. It doesn't include masks, and thus threw out the mask mandate a few days, admittedly, before the federal government under President Biden wanted to put it aside, but nonetheless threw it out, saying it's beyond the powers of the CDC to call for such programs. A very limiting reading, in that case, not of the Constitution, but of a statute. There are other ways, I want to say to you at the outset, to read the Constitution. First of all, as Justice Sotomayor more or less cried out in the middle of the oral arguments on the Dobbs case, the Mississippi case, something as basic as judicial review, namely the power of the justices and judges to decide that laws are unconstitutional, was not mentioned, not a peep, in the original text of the Constitution, and barely alluded to, and not at all clearly in the Constitutional Convention. So that's the foundation of Article III judges, of federal judges, and yet it wasn't mentioned. And there are many other areas where the structure and meaning of the Constitution has to be deduced from a more generous sense than just originalism or textualism of what these framers were trying to do. Another point to make here is that I believe, and I think I can prove to any of you who is skeptical of this, that any law, even a parking law, has as its basis some kind of moral judgment about what makes sense and what's good for a particular community. Just about anything you mention in law will be based on some kind of moral dimension or moral concern to protect people, to help people, and so on. And that way of looking at law, what's it about? How does this help? What kind of vision is implicit in, say, our Constitution for the people, is one that I think is just so much more basic and important and powerful than any ideology like textualism or originalism, or even a liberal ideology like a living constitution or something. The point is, people were trying to found a government for a free people. They had a totally blinded sense of what a free people was. We know that. So they kept out African Americans, and in Dred Scott confirmed that at the highest level. Almost 2 generations past the framing of the Constitution and just before the Civil War. They had a blinded view of women and of many other aspects of this vision. But I think the fundamental vision of a good government or a good constitution for free people is in fact what animated them. And as Ronald Dworkin, the great jurisprudential philosopher, said some years ago, when your parents teach you a moral or legal principle, if your parents themselves were biased or bigoted, but nonetheless taught you a principle like fairness, shouldn't you, in thinking about it, think about what fairness means as you understand it as life goes on? Or should you throw back to your grandfather and say, well, he taught me fairness, but fairness excluded slavery, for instance, or the enslaved peoples? And it seems to me obvious that that kind of moral component is in effect very important in any working and practical, pragmatic judicial system or Supreme Court. It seems to me really a tragedy for America that we've fallen into the hands of this right-wing elite, really, or right-wing leadership that has this crabbed and confined and I think fundamentally fictional view of what it's about. A fictional view based, as I see it, on an arrogant sense that they can find the true meaning of this or that. And for a further arrogance that I think is a problem here, even on the liberal side, and we saw it very recently in some speeches by Clarence Thomas, by Amy Coney Barrett, by Stephen Breyer and others, is this notion that one's own, and by the Chief Justice, is that this notion that one's own psychology and background and political preferences will not intrude in one's judging. It is a really dangerous illusion, it seems to me, for judges to hold this view. Much better a judge who would admit, I have a background that might influence me, I have a politics that might influence me, but I will work hard to counter any unfairness that arises from that, than to have someone like Amy Coney Barrett or Stephen Breyer say, the judging job, we put aside all our personal predilections and our psychology and all the rest of it. And the rest of us sit here, it seems to me, and watch these justices and their results and just thinks that's baloney. It's a fib. And what's worse, they're fibbing to themselves. They're kidding themselves and get themselves in this corner where they hold high pretense of fairness and dispassion and impartiality, while a low psychology and politics is actually operative in many, many of their decisions. Now, I want to turn quickly to the several questions that have been asked and to give them the privilege of having come in first and making an effort to answer them. I'm not sure whom this one came from, but one question that came in is, we all know that early on in her career, Ruth Bader Ginsburg, in a famous speech at NYU, as it happens, came forward, and it was later published as an essay, to say that she too agreed that Roe v. Wade had been wrongly decided in the sense that it was put on the wrong constitutional basis, a basis of the right to privacy and an interpretation of the Liberty Clause of the Equal Protection, of the 14th Amendment. And the question then says, if that's right, if Ruth Bader Ginsburg preferred the Equal Protection Clause of the 14th Amendment, that it was women's equality and ability to go forth in the society and succeed and prosper that was really at stake in the right to choose, because without it, family life or reproduction would constantly hamper your ability, unpredictable reproduction would constantly, and child rearing would constantly hamper your ability to have a career and a profession. It was simply unworkable in a modern society in which women and men could equally hold positions of authority and positions of work in the society. And so the question, is she right about that, one, or was she right about that? And two, would the the ERA, the Equal Rights Amendment, make such a difference that it would guarantee the right to an abortion? And on the latter point, I would just say the Equal Rights Amendment will only be as strong as the justices and judges who interpret it. And so there, I think clearly we don't have an Equal Rights Amendment fully fledged yet or fully archived and certified, thanks to the Senate. But it seems to me it wouldn't make a difference ultimately in case-by-case adjudication, because the justices and judges would have to decide what it meant in detail, which is, again, the job they have. And the job that they would no doubt argue through textualism, originalism, didn't include abortion or some such. Is Ruth Bader Ginsburg right that equal protection was a better approach? My own view of that, as somebody who's written about the right to privacy and liberty under the 14th Amendment more than I've written about the Equal Protection Clause, is that judges, whichever clause they put it on, it seems to me there's a kind of convergence of their thinking such that I don't think it would have made that much difference. I know Linda Greenhouse, Reva Siegel, a number of scholars do, and felt that it would have been much better and would be better now. I simply am skeptical of that. I think that's a kind of formalism. I think ultimately the question is, what are you doing about this fundamental question? Can a woman have an abortion? Can a woman have a right to choose? And does the Constitution protect it somehow? And it seems to me it's a merger of equality concerns and liberty concerns, freedom concerns. Ellen asks a question, which is a technical question, but of interest, and that is, so I'm going from the general to very particular, what about miscarriages and ectopic pregnancies and their treatment in states that have that get rid of a right to choose and that make it in some sense criminal? And she points out that the medical procedures used for ectopic pregnancies, and in some cases for miscarriages, are very parallel to trying to preserve the woman's health to the procedures used for a surgical abortion. And that's right. And I think that to the extent that the states continue to say that a woman's health and life allows a right to choose, those procedures will be safe. What's dangerous and what lurks in that question, Ellen, is that a zealous or a reactionary prosecutor, and we've seen this happen already, when we get rid of the right to choose, when the court gets rid of the right to choose, and when states follow suit and have their laws, their trigger laws and other laws go into effect, they could easily take the grayer cases of a doctor who says there was a dangerous ectopic pregnancy and challenge that judgment. States do have a power to regulate medical practice, as we've seen in their chipping away at abortion rights. And it seems to me there'd be a chilling and a real danger for medical personnel as well, possibly, as for the pregnant person in this. But there's no simple answer to that. It really will depend on the persecuting and prosecuting powers in these reactionary settings. And it also, to some extent, and somebody was saying the other day, in cities like Austin, Texas, where you're likely to have liberal juries, you might get jury nullification of a prosecutor, or a real bar to a prosecutor, or you might have liberal prosecutors. But it's not going to be simple. It's going to be messy, and I think it's going to be dangerous and chilling. Other questions. Bernadette says, what about impeaching the justices? How do you impeach a justice? Well, I think we all have a sense of that. First, it's damned hard to impeach anybody, a president, a vice president, a justice. Impeachment is the only way to get rid of federal judges who have life tenure. Only, I think, 9 of them have been impeached in the whole history of our country. One Supreme Court justice, but acquitted. And it seems to me it's just, there's no way in which these justices are going to be successfully impeached. Sure, you could have a Democratic House that might bring articles of impeachment, but there's no way you're going to get a sufficient majority in the Senate to convict. And so the House alone brings these articles of impeachment, and I think it's a very dubious notion that it might make any kind of difference in this time. Indeed, I'd worry more about liberal judges as we go through the next midterms and so on and so forth. Mal Wasserman asks a question of real historical interest, and I wouldn't pretend to be an expert, but what was the reaction, he says, to other bad decisions, any instances, Plessy against Ferguson, the separate but equal train case out of Louisiana? And I did poke around to try to answer that, Mal, and in general, the reaction to Plessy was I looked at several newspapers in the Library of Congress that just shrugged their shoulders and said, well, separate, that's fine. And what was more notable was that the small but persistent and important Black press, particularly down in places like Louisiana, were very, very focused on it and how unfair it was to throw Homer Plessy off that railroad train. And it was a test case brought on purpose by people who said this is an insult to us. And as most of you know, the opinion in Plessy said that there's no insult in separate but equal. If an insult is taken or felt, if offense is taken, It's because African-American people have taken the offense. It's not that any offense was meant. And as one of my teachers said to me when I studied constitutional law, that elicits the sovereign prerogative of philosophers to just laugh and ridicule what's said. Of course, it's an insult. It's a subordination. And Justice Harlan's great dissent articulated that insult in ways that are still important. For instance, he said, "We have no caste in America," foreshadowing Isabel Wilkerson's great book on caste. He said something a little more controversial, that the American Constitution is colorblind, prefiguring Martin Luther King's sense of what the Constitution should mean. And this is from a person, Harlan, who in many, many ways embodied what we would now call racist views. But he thought the law had to be colorblind. The law could not have a dominant and subordinate class. And he used just that kind of argument in his lone dissent, which was admired by people who staunch, in those days, Republicans who were against Jim Crow and fighting it and so on. But I think that was a minority strain in the press in the United States. The United States at that point was very accepting of certainly separation of the races, but also acquiescent in its own way in Jim Crow down in the hard rights or the hard racist states in the South. I think that covers the background. Catherine asked a very interesting question, which is the question that came up just last week in the failure of the right to choose legislation in the Senate, having passed the Congress. So what about national legislation, assuming that Roe and Wade is overthrown? Let's assume first, Roe and Wade is overthrown and we have another period of democratic success. I think many of us are skeptical that that's about to happen, but we have a Democratic president, a Democratic House, and a Democratic Senate sufficient to pass legislation. What about national legislation to guarantee the right to choose? As I said a second ago about the ERA, the Equal Rights Amendment, the problem is national legislation can be overthrown by judicial review at the Supreme Court. And I wouldn't put it past the Chief Justice and the other right-wing justices to say that it's an overreach on the part of the federal government to tell the states that they have to allow abortion. And the answer from the right wing would be that our Constitution was set up with a mind to limit national or centralized power, to limit what was then the power of a past monarch, and that the states were in charge of their own criminal laws. And if they want to criminalize this or that, and it falls within the general pattern, they could do it. We've seen the Chief Justice do this with the Shelby County decision, where they gutted most of the Voting Rights Act by saying, yes, Congress passed this, but it takes away too much of the sovereignty of the states. The states are treated unequally. Therefore, Alabama, you're now as free as California to make up your own election rules, whereas before Alabama had been under the Voting Rights Act pre-clearance rules where they had to get Justice Department approval, and the approval required the Justice Department to say there's no prejudice here, there's no continuation of some kind of echo of Jim Crow here. So I think there are real problems with national legislation. Let's assume the contrary hypothesis, that we have a Republican president, a Republican House, and a sufficient Republican majority to have, let's say, a personhood amendment, a denial of the right to abortion across the whole nation with whatever exceptions and so on they might make. I think that's a real worry. I think this Supreme Court would uphold it, notwithstanding the inconsistency with what I just said a moment ago. Or might very well uphold it, and I think it's a real trumpet sounding to say stick with politics and try to stop such majorities, because they really are dangerous, and we're in a dangerous pass here in these years and possibly decades for the American government system. Let me finish by saying here that I think all of us are very, very well aware that the Electoral College, the Senate, money in politics. There are a lot of anti-small d democratic forces at work in the United States of America. This ain't the democracy we dreamt of and believed in as kids. This is democracy that is hampered and corrupted by both almost absurdist, but certainly anti-democratic old institutions like the Electoral College, like the 2 senators in every state, no matter how small or big. And it's a democracy in which there is, we know, a kind of minority rule. Those who lose the big elections win the big power. And it seems to me that's really, really hard to change. But that's what needs to be changed for us to have the kind of democracy and the kind of respect for each other, including for women and their choices and their bodies, that we'd like to see in the United States. Now, having said that, let me finish up and ask Ellen to codify. I can glance in the chat, but you've had a chance to really read it and give us some other comments and questions as we go forward. And I'm sure I've left a lot out.
Okay, Tom, I will tell you, I've been trying to write as quickly as I possibly could because the questions have been coming in fast and furious, and to me, they're amazing. Okay, so I'm going to start at the beginning. Someone is asking, what can we as the public do to change this now? And what's the most practical way to overcome future court decisions, legislation from Congress, etc.? I mean, we all want to know what we can do about it. There was a question about, is there a way to work to get a national, to work with the Democrats to make sure that there's a national response to this if the court does ultimately overturn Roe. So I think I'm starting with the end because I'm hoping you can give us something to look forward to because I'm very depressed now and the questions coming in are worse.
The answer is notwithstanding, we're like that horse at the back of the pack. I mean, we have the Senate against us. We have the rural, the rural favoritism, if you will, against us. We have gerrymandering mostly against us. Those of us in New York just had a setback on the Democrats' effort to gerrymander in the other direction. You in Massachusetts invented gerrymandering with Elbridge Gerry. It looks bad to me. It looks as if the bleak polling on the midterms, the bleak polling on President Biden suggests a difficult period. I'm skeptical myself that Trump will win again, and maybe he'll run and we could beat him. But it looks to me hard for us to get the kind of Democratic majority, the kind of liberal majority in the House and the Senate that could succeed in legislation of various kinds. And don't forget, one of the most important kinds of legislation, echoing back or harking back to FDR, is to change the court. The court, in my view, I don't think it makes sense to simply pack the court, but I definitely think it makes sense to have limited terms, lengthy, limited terms, 12 years, 18 years, a regular sequence of retirement and appointment, as Buttigieg and others have advocated. I think it might make sense, although this is a steep hill, to have a large Supreme Court like in India, the largest democracy in the world, where panels, like in our appeals court, on the model of our appeals court, handle it. So you're not, when you think about Ruth Bader Ginsburg's non-retirement and how absolutely decisive it was, even now, because the Chief Justice is somewhat movable if he's in the middle. It's a pretty crazy system that one frail, if I may say, old lady, one frail person pushing 90 can hold the whole, like the little Dutch boy, with the finger in the dike. It doesn't make sense. And so the argument by Professor Jamal Green at Columbia and others that we might consider in a comparative law fashion a big Supreme Court with panels of 7 or 9 justices. So they're deciding these cases, they're deciding the others, all the while working. We can afford it, and it makes some sense to me. And the Supreme Court needs to be reformed, it seems, just as much as the Electoral College, the Senate. And there are ways around. We can make Washington and Puerto Rico states. That's much easier to do, much less stoppable, if you will, although we have been stopped. But those are workarounds in a sense, because the fundamental unfairness that a teeny state like Vermont or Wyoming can have the same representation as a monstrous state like California or Texas or New York, states as big as much bigger than most of the countries in Europe, like Sweden or what have you. It doesn't make sense, and it's a real blight on our democracy. The Electoral College, the Senate, these various compromises that were necessary at the time, just as the compromise on slavery was. But really now we have to shuck them off, as we shucked off after the Civil War, at least slavery in itself. But I too am somewhat skeptical. I think this is going to be a long haul battle. And some of us, I know many of your people here are scared we're going to lose. You hear often Jonathan Haidt and other people, I believe in 10 years, the probability is we're not going to have it in. Well, I'm a little more positive than that. I'm much more hopeful than that. But I don't think it's going to be the wondrous democracy we used to talk about in high school, or a lot of us did. We may have been against the war, but we thought on the whole, America had a good democracy. I think it's a really botched democracy in so many ways.
So is the short answer, and thank you for the long answer, but is the short answer that we have to start to reform at the local level and work our way up?
I think this whole thing that we've learned about secretaries of state and elections, that varies from state to state. Many of us are involved locally, although both in New York and in Massachusetts, the two states mostly represented here, we have pretty blue politics. Not ideal, not perfect, but blue. But and not enough of us live in Arkansas, Oklahoma, Texas, and so on. But it is the case, I think, that the states can be. We know that to take the right to choose, the states are going to be if we can keep down national legislation of personhood, keep the Supreme Court from deciding that the 14th Amendment extends to the recently conceived fetus and so on. I think the states are where there will be abortion. There have been articles about Poland. I saw a long article about Poland in the New Yorker. The idea that the pills, which are supposedly half of abortions now, are small and shippable and disguisable. And heck, people have been buying drugs for a long time and not that expensive. And can be provided trips by airplane and so on. Those things will be the battleground, because these states will go after all of that. Absolutely. And there will be some brutal persecution of people who try to do it. But I think, as with the war on drugs, they will mostly fail to stop the actual practice and usage of these things. And thus, I think that's in terms of young women and poor women, that's really going to be the remedy. State politics that make states like Connecticut, New York, and Massachusetts, et cetera, generous, and Planned Parenthood buying a lot of airplane tickets with donations from groups like this.
In your response, you just opened the door to a couple of different directions to take this, and I see that there are that many more questions coming in the chat, so I hope we can get to everybody. Someone was asking if murder of pregnant women can include a charge for the murder of an unborn baby. How can the laws say that an unborn baby isn't a human life? This is the other end of the spectrum, I think.
Okay, so would you restate that? Because if then, it was an if then question, am I right? Right,
you're absolutely right. If murder of a pregnant woman can include a charge for murder of an unborn baby, her unborn baby being pregnant, how can the laws say that an unborn baby isn't a human life?
Under Roe and Wade, well, it's interesting actually, and I don't, under Roe and Wade, there would have been let's assume Roe and Wade is put aside and reversed, and we have Roe and Wade. I think that there will be a tremendous push to say that the fetus at some point and the Roe and Wade itself sees the state as having an interest in the emerging or the gestating fetus after 3 months and then after 6 months after viability that is protectable. I mean, don't forget that. Roe and Wade wasn't just, as Reva Siegel, who's one of the most ardent advocates and scholars here has said, it's Roe and Wade didn't say just, yes, have abortions no matter when, no matter why, no matter, et cetera. It was a pretty regulated system. And that regulation was premised on the notion that, quote unquote, the states have an interest, which is to say, can assert a value in the gestating human fetus, the so-called emerging human life. And I think that's true. This is for most of us, this is a fraught emotional, psychological, and moral issue. And I think very few people believe that that it's just nothing going on here. It's clipping fingernails or something. So yes, states will assert, can assert, do assert. Louisiana is asserting right now that to extinguish, to abort a fetus is murder, or manslaughter. I mean, I'm not sure which exact term they used, and they want to criminalize it for both the bearing pregnant woman and for anyone who helped or performed such practice or gave medicine and some such thing. So, no, the question is well said, and I want to say, if that question comes from someone who might say, well, gee, this is an awfully liberal group to hear this out and so on. I do want to say, I think we all need to respect one another's views. It is, and let me speak as somebody who was raised as a Catholic, albeit I acknowledge that I am a skeptic and non-believer in all religions at this point in my life, but I see them as very important in human life. I respect people who hold views based on philosophy or religion, atheists or religious people. Most of them are in this country and in Christian. Many of them are Catholic, although fewer than are evangelical Protestant at this point, I think, because a lot of Catholics defend Roe, as President Biden and the good Mario Cuomo did years ago. We have to respect one another, and it's perfectly arguable that we have human beings here and we should respect the sacredness of life. Dr. Schweitzer in Africa and so on, all life is sacred. And of course, the argument from the pro-choice side is, if all life is sacred, why aren't we sustaining good medical care, lower infant mortality, and so on and so forth? But here's my view of why, even if you are, like President Biden, religious, why this right needs to be in our Constitution. And I'll just give it at its most pragmatic level. You cannot stop women from aborting fetuses, especially in the early months, no matter what you do. And the only way to stop them is brutal, intrusive, invasive, and oppressive. And it creates a government, a police government, a police state, which is, I think, to most of us, really inconsistent with what we want and what the Constitution seemed to suggest, imperfectly, but nonetheless. That is to say, a free society. Control over one's sexuality, over one's reproduction, is really basic. And in that sense, I am a believer in the right to privacy, the liberty, interest in one's autonomy of bodily choices. So I can understand. I had an uncle who was a bishop. I can understand arguments the other way, and I respect them. They're I think many times very sincerely held. But to create a governmental system that will enforce, let's say, no abortion after conception or no abortion, after an early, is brutal. We know that from the past, and it's now going to be, I think, both less effective because of the pills. Mifepristol, right? And it's just not doable. And some things in life the government shouldn't try to do. So that's my answer, but it's a tough and good question.
Okay, thank you very much for that. You were saying before, you mentioned Roberts, and so there was a question about, what does this say about Roberts's future influence on the court and his control of the court?
It's Alito's court, as who said that? And did Linda Greenhouse say that the other day? It's Alito's, it's Scalia. It's Scalia's influence in Alito's court. And I was reading more the other day, and I just reminded me of the shocking fact that I'm pretty sure Scalia was confirmed to the seat on the Supreme Court 98-0. And that's just extraordinary. I mean, we have become so much more riven, and especially the Republican Party has become so fanatically oppositionist to the views of those of us on the liberal or left side of this thing that's just inconceivable now for any justice. And of course, we saw what happened with the, you might call it the gypping of Merrick Garland and so on, that created another right-wing appointment on the court. Anyway, I think that answers it. And for me, go ahead.
Okay.
We'll get as many questions as we can.
There was a question, can this take down Griswold versus Connecticut, and what would be the consequences?
So you all saw, if you looked at either excerpts or the 70 or whatever number, I mean, a lot of the pages are appendices about various state laws, but in Alito's draft opinion, you all saw that he's very emphatic to say this does not touch on same-sex marriage, homosexual, I forget how the list, but privacy, contraception, and so on. And let's assume he's sincere in that. It's not much of a guarantee, because the Griswold, for those of you who may have forgotten, is the mid-60s case from New Haven, Connecticut, where a test case was had following another case that had lost in Connecticut of a birth control clinic explicitly for contraceptives, in other words, for married persons, trying to challenge the intrusiveness of Connecticut's old Comstock law, saying you couldn't use devices, et cetera, et cetera. And Griswold was one on what is the most famous basis of finding, Justice Douglas wrote the majority opinion, that while contraceptives and sexual intimacy were not identified in the Constitution, that wasn't what the framers were putting in the Constitution, you might say, or thinking about it as they wrote the Constitution. Nonetheless, it was implied. And I take it that that's a kind of structural argument, implied by a lot of other clauses that protect the home and that seem to create a government that would not be oppressive and intrusive unless it had to be. And in the case of murder and crime and so on. And so he says, Griswold, in effect, he says, Griswold will survive, or at least the rights there will survive. I think a lot of us are nervous about that, because a defiant and triumphalist right, a right that is mixed in evangelical, religious partisans, fundamentalists of various religious stripes, and others are campaigning so passionately and furiously on this issue, and they have allies in the white supremacists and the MAGA nationalists and so on. So there's a big political force, I think, that will ally, as happened in the years following Roe, to try to push it back. And that leads to the question, the embarrassment, you might say. 7 of the present justices on the Supreme Court, well, we're about to see 6, grew up in Catholicism. And in the conservative majority of 6, all of them grew up in Catholicism. And it is true, I think, that a couple of them have drifted a teeny bit towards the Episcopal Church in the case of Gorsuch, because his wife is British Anglican. I think towards Congregationalism or some other religious affiliation. In the case of the Thomases, Jenny Thomas is obviously a zealous, fanatical, fundamentalist, whatever denomination she's in. And but they all grew up in the Catholic Church, and they're all coming to a result that accords with the hard version, the Pope's version, or past Pope's version of Catholicism. That's a weird situation and a strange embarrassment. And I love it when Linda Greenhouse denounces that and just says, what we're getting here is the imposition not of a philosophy, but of a religious doctrine. The doctrine sings loud within them. And it's embarrassing. It's shameful. Just as shameful as Jenny Thomas's involvement and her husband's no doubt support for January 6th. It's shameful and unacceptable to have a religious view that's so clearly not the majority view of the country, and not just that, but passionately resisted around the country, now about to be set down in our law as the view of taken on a reading of the United States Constitution.
Well, thank you for that. You've in essence answered a couple of the other chat questions that came in, so that makes my life a little easier. But it also opens up the question, you've touched on it a couple of times, about the effect on privacy and the other rights that are protected by it. Interracial marriage, gay marriage, contraception.
Gay sex, yeah.
And right. And then someone just also mentioned, which I have to admit hadn't occurred to me, about IVF fertilized eggs. What will happen to, I'm speechless, which for me is quite a thing to say. I mean, I don't know if do you think that as a result, assuming that Roe is overturned, that all of these various things that we've taken for granted will be ultimately attacked, for lack of a better word?
There'll certainly be an effort to erode them and attack them and chip away at them and so on. And I think it includes IVF, because I don't know in detail all of the various religious denominations that are a lot. I mean, there are a lot of, it's mostly evangelical Christians and Catholics, but we all know that the ultra-Orthodox Jewish congregations have pushed readings of the Talmud back from the notion of breathing and breath towards something else. And I mean, there's all sorts of literature, really fundamentalist Muslims, et cetera. I mean, there are just a lot of, I assume this may be true in almost any religious strain in the United States, that you're going to see the hard or more fundamentalistic people saying, you know, life begins here and we got to protect it and so on. I think all of these various rights are suddenly more insecure. Do I predict that they will all go? No. I think there will be, I mean, this is again naive. I think there will be restraint. I mean, I hate to say that about people I'm condemning, but I think there will be some restraint and some constraint from precisely the politics of America, where we know that the majority, depending exactly on how you ask the question, supports not just IVF. I mean, that's probably 99% of people, but supports abortion. And I can say from my own knowledge of Catholicism that more than half of Catholics seem to support abortion. And my dad used to always say when I was a kid, and he was an old-fashioned civil rights Republican, that he would say, Tommy, just think about all those hypocrites in the Connecticut legislature who condemn abortion, but then if their teenage daughter gets pregnant, they'll sneak her off to wherever, et cetera. I mean, there's tremendous possibilities for corrupt hypocrisy in all of this. And we see that so often with priests who abuse children out of their sexual urges, I mean, just all sorts of things. In so many communities, we see that these public priggishness and condemnation and, oh yeah, I have a higher moral standard than you do, is held by people who themselves are betraying their moral standards left, right, and center. So.
Well, thanks. Now I'm getting discouraged again, but
hang in there.
We continue. This is a slightly different angle. I think it's interesting. Someone had written, what legal rights would be assigned to zygotes and embryos of the carrier, meaning the woman, if the woman is harmed, meaning what would happen in the case of assault or manslaughter, and as part of that question, what impact would there be on estate laws? Thought that was fascinating.
So even at present, states can, just as with hate crime, you can say if someone I mean, this has been true, and I hate to say it, but Alito alludes to some of this in talking about, Matthew Hale and some of these ancient jurists in England who had very retrograde views of marriage and all sorts of other things, but might have also condemned later term abortions. The states have a lot of power here to regulate medical practice and to regulate crime. And I think all of us, if I have not had this experience, but if my wife, when pregnant, was attacked by someone, and let us say she was harmed, killed, let's say, but it's a double tragedy. If we see that all the time in car accidents, if a neighbor loses her life and there was a child, a gestating in there, or a fetus gestating, I think many of us recognize that's a real harm. This is why I want to be clear that we don't have to be such, I respect a lot of views here, but we don't have to say that, and Roe and Wade did not say that a fetus was nothing, that a state could have no interest or no concern. And so similarly, the criminal law can take heed of harms of this kind. And yes, this will encourage, if Roe and Wade goes as we think it will, and Casey goes, this will encourage states to make the severest penalties for harming a fetus. And that will be part and parcel of their prohibiting abortion, even very early on, right? The 6-week notion that's had in Texas, and maybe the conception notion that's being pushed.
Okay, so this is great. It's almost as if you're setting me up. I appreciate this. There was a question that said, if the majority says the 15-week limit in Dobbs versus Mississippi is compatible with Roe, then thus letting Roe stand in principle, would that mean that the Texas 6-week prohibition plus would it become a moot point, or would it stand?
So you probably, a lot of you have probably done as much reading on this and thinking about it as I have, but take a country that was steeped in a kind of an old-fashioned Catholicism is Ireland. And I can say this because my forebears mostly came from there. They now allow abortion up to 12 weeks. Well, that's much more limited than Roe and Wade, but it is 3 months. It's not nothing. 90 or 95% of abortions occur in that period in the United States of America. And with better health care, maybe a higher percentage would, with freer and more clinics and so on. It is the case that, that you can work these things out in a compromise. And that's why some of us, I don't know, Ellen, I think you participated the last time we had a talk like this for your gender group. And the question arose, what's likely to happen? Well, one possibility was Roe and Wade will be upturned and overthrown. Another possibility was there'll be a compromise of a European sort. And I think all of us have become familiar in the last few weeks to read the papers with the fact that, with the exception of, say, Poland and maybe Hungary, I forget, most of the EU countries have set some kind of standard. The most radical of these standards, interestingly, and just as a footnote to this whole discussion that I did not know until I was preparing for this, is Germany actually says life begins at conception. However, during the first 3 months, there is no punishment for abortion. So, and it's seen as a kind of inconsistency or compromise over this, where on the one hand, this reflects the Dr. Mengele, all the terrible things of the Nazi period and the guilt about it, the sense that Germany has to respect life. And so they have this interesting compromise where they, on the one hand, agree that life begins at conception, but on the other hand, allow abortions for the first 12 or more weeks and allow many, many exceptions thereafter, for health, for psychological well-being, and so on. So it's a relatively permissive abortion regime or choice regime, but it does sort of accept a kind of philosophic point that we can accept that life begins at conception. And I thought that was extraordinary that they would, just reading their constitutional court, had held that way.
Yeah, that's interesting. I wasn't aware. So here's a question. The question is, can the court assert as true matters that are not validated scientifically and do so with impunity? So that comes back to the question of, if a doctor says that we'll call it, if a doctor says that an abortion is necessary to save the life of the mother, or because the fetus is not going to make it, or whatever the reasoning is, if the doctor says that, can the court, have their own ideas if they are not using scientific thinking? Or I'm not sure the right way to put this, but hopefully you understand.
Yeah, no, so let's remember what the court is doing is essentially saying whether a state law is constitutional or not. And up to this point, they have said it is unconstitutional for states to intrude on the liberty interests of a mother up to viability or up to roughly viability in the Casey case, to put an undue burden, to use the Casey standard, on a bearing pregnancy before a certain point. And after that certain point, exceptions can be had depending on the state law and so on. But we've seen the states, the harder right states, really get persnickety. The Texas reduced to 1 abortion clinic, Louisiana shut, they're making it harder and harder to exercise this asserted right. Now, if the court gets rid of that constitutional right and leaves the states free, as Justice Kavanaugh said in the oral argument, to make their own popular, quote unquote, democratic decision, even though we recognize gerrymandering, it's not as democratic as it's cracked up to be. The states can do a lot of things. And if they did it in an irrational way, it's possible the court would say no, but there's a very low standard on the rationality of medical care. States can impose all sorts of rules in medical care that could be very restrictive or very permissive on the basis of legislative judgments. They'll probably listen to a few experts, and there are many experts on all sides of these issues. So I think the science in any, well, of course, science is always hard. Look at COVID. I mean, people can argue science, till the pandemic ends, which apparently isn't, right? I mean, there's still, I just listened to This Week in Virology last week, and they said that the most recent study of ivermectin showed no effect whatsoever, but there are still doctors proclaiming, and there'll be more studies of, I'm taking what I think of as probably a bogus treatment, but Paxlovid is, continued to be studied for its good effects, et cetera. Science is always evolving, never completely certain. So I think that's not quite the way it'll be judged. It's more, is this an intrusion on somebody based on a complete irrationality? That'd probably be overthrown by most courts, even state courts. But is there some rational basis, which is the low constitutional standard, for a medical rule? There could be, there probably will be. And and all of us can sit back here and say, well, that's really based on that guy's religious prejudices or that majorities, legislatures. But that's not a strong argument. It's not a winning argument, because you can always say, I don't know how many of you listened to the oral argument. I think it was Alito who said to I forget if it was to Prelogar, our Solicitor General on the liberal side, or to the Solicitor General of Mississippi, are there non-religious philosophers who condemn abortion? And the answer, of course, is yes. There are plenty of atheists who are against abortion. Plenty. There are few, but there are enough and scholarly enough so you can find articles. So I think, Ellen, there's no clear path on this. That's a straw in the wind. That courts will condemn something just because, quote unquote, science doesn't validate it.
Okay. Taking this in a different direction now, someone wanted to know if the nominees perjured themselves when they testified that Roe was settled precedent.
David Rudenstein thinks so, and a lot of other people do. They certainly, we don't know exactly what happened in the offices of the senators, which may be more important, as with Susan Collins. But there was certainly some kind of shell game going on, and that's been going on in our confirmations for a long, long time. Oh, I can't comment on that because it may come before the court. Oh, blah, blah, blah. Don't intrude on Amy Coney Barrett because she's a religiously motivated person, et cetera. The fact that she wrote this petition, the Republicans would yell at you if you try to hold that against her. There's a lot of shell game playing going on in this, and it's sad that it is. I think it's probably inescapable. In any political system, that people are going to hide what we used to call, using a football analogy, hide the ball, kind of, in these kinds of things. But they're hiding a lot, and so I think that we were all misled, but some of us were cynical and saw right through it, that it was just an evasion. The ball was there; they were just hiding it. Susan Collins, I hate to say it, but in some ways I admire her, but a lot of people think she was fatuous and foolish and gullible, right? Like a kid, in not being more challenging on that. And so, yeah, I think there were a lot of shell game playing, but did they actually explicitly lie? You know, did they say, I will not overrule? I don't think so. They just, this is where precedent comes in. And that I thought there'd be a question about precedent. As you know, the Latin stare decisis, stare decisis is the pronunciation. To stand, stare, like it is the root of our word stand. And decisis is obviously the, you know, decisions in Latin. And I think it's in the plural. And stand by the things decided, the decided cases in effect. And in constitutional law, that's always been a little uncertain because of these great reversals, or even non-reversals. Plessy and Ferguson reversed by Brown, Dred Scott reversed by the Civil War and the Civil War amendments, you know, and then sort of reversed by Jim Crow and racism. But now we're kind of working on it. In many decisions in constitutional law, are reversed. Marriage itself as a gay marriage is something that came up through the courts with lots of uncertainty, and then finally was held to be a constitutional right. On and on and on I could go. I think it's not good to count on stare decisis in constitutional law over much. But on the other hand, the shell game, people praise it and bow to it, and, you know, and so on and so forth, in order to say, oh yeah, I really respect precedent. Until along comes Alito, and in the draft opinion, quoting his buddy Kavanaugh, who spoke exactly in these words at the oral argument, what if Roe was egregiously wrongly decided? And so in the draft opinion, he says it was egregiously wrong from the start. So there's always a loophole on anyone who says respect for precedent, and there probably has to be. We would not want to have the Brown versus Board of Education case say, oh, well, we'd like to not have separate but equal schools, but if we go back on, you know, whatever it was, 100 years essentially, you know, well, there was a precedent that stood all these years, and therefore we should stand by it. So that's an ambiguous thing.
Okay. So here's a question, since you mentioned, well, we've been talking about the leak all along. Someone is asking if the leak was made on purpose to test the results on the population. In other words, to get people's reaction. And I mean, I think the answer is probably
who knows?
Yes. But
yeah, but we don't know. We just don't know.
You're right.
You know, the other leaks that have been made, nothing has been quite this dramatic. Although I think it was in Plessy, if I'm not mistaken, that the great Justice Harlan, himself sort of a racist, but what you might call a good racist, good trouble, because he stood for no caste, no class, no dominant group under the Constitution. Like Lincoln, he would say things like, I happen to think, you know, my race is better than your race, kind of thing. And he did say that in the opinion. But nonetheless, he really was the lone dissenter in Plessy and Ferguson, and just that our Constitution cannot accept separate but equal. It's an insult. It's a caste. It's unacceptable. And I think his dissent was published in the Boston papers on the basis of a leak, and it got him in trouble. If I'm not mistaken, I may be confused, but anyway, there's been a case like that. So I don't know what the heck the leak is. It could have been a printer. It could have been a secretary. You know, they have a lot of ways to try to hold on, but there are a lot of people in that building. Each justice has 3 or 4 clerks. They have secretaries. There are all sorts of people, guards and stuff, who might have seen something and filched it. I mean, I think it'll be fascinating in a kind of a mystery way to learn and see who suffers for this. An interesting sidelight on it, that a question I didn't answer is, somebody was saying about ethics at the Supreme Court. The Supreme Court has no ethics code at this point. That's the big deal about, because the other judges do. Sexual harassment and so on. Some federal judges have had to resign over things like this because they do have an ethics code, but as well as various laws constraining them. But the Supreme Court has laws. They can't go out and murder somebody, but they can invest in companies. They can do all sorts of things. They can have their spouse go out and campaign, you know, to disrespect an election and so on. at least technically they can do this because there is no code. On the theory that they're the highest justices who are in charge of any codes that apply to the lower judges, they don't apply it to themselves. And that's why there's no criminal law that applies here seemingly. And it'll just be, but I think the result may be, because I think Chief Justice Roberts is very passionate about this, that we may get an ethics code that applies to everybody who works there. And I hope to the justices. And I wouldn't be surprised that behind the scenes, he's pretty upset with the Thomases about their involvement in the Trump big lie.
Well, but if there is an ethics code that comes into play, that would be after everything
After
that we're talking about now.
yeah,
Anyway.
there is no ethics code.
Okay, and now I'm going back to the chat. I ran out of everything I was scribbling from before, so bear with me. But there's a
question here I want to interrupt for a second because I see it
Sure.
just at a glance from MP. Can a state criminalize the interstate shipment of an approved drug through the U.S. mail? How about the tasting of if it is federally approved? This is a very important question because, as we've already said, something like half now of abortions are had with pills or medication. In other words, they're self, how would you say it? I mean, they're self-taken medications. They may have been prescribed or given by a nurse or a doctor, but they don't really have to be. They are in effect through the mails or across the counter.
Right.
And what the states are first going to do is include those pills in all their prohibitions and say, let's say Texas gets away with criminalizing abortion under whatever exceptions and with whatever limits, I'm sure it will criminalize abortions had by pill as well as abortions had by medical intervention physically or with surgical equipment and so on. So then the question goes, what if I get the pills from Europe or I get the pills from New York or I get the pills? Well, I guarantee you Oklahoma and the other states like that will try to somehow reach out and grab jurisdiction over the person who sent the pills from another state. The Postal Service is a federal operation and in theory, should not be intruding on that in theory, and as long as we have an ability to not pass legislation to Congress, that probably would obtain. But if there's a Republican majority in the House, the Senate, and the President, you might get some laws that allow the Postal Service to intervene as they do with child pornography or terrorist material or other things. So this is a point of real vulnerability. The second sort of strain of this is it's very clear that Texas, let us say, to use that as an example, might say that a young woman who wishes to have an abortion and talks to someone in New York or has someone intervene to connect her with New York or Europe, either to get the pills or to get a travel, is conspiring in Texas to commit a crime elsewhere. And that raises the right to travel, freedom to talk, and so on and so forth. And those are close questions, which, again, depending on how reactionary our judges and justices are, could go in effect either way. Those are, again, vulnerabilities. I think the strongest force in this will be the public opinion and politics and the difficulty the cops and the states will have in catching people using those pills. Now, that leads to a third point. If some percentage of the young women who use such pills will have medical complications, it's a very small percentage, smaller than through surgical, at least this is what you read, smaller than through surgical interventions. Those young women, let's say, going to a clinic and being examined and so on, will be very vulnerable to some kind of trouble in those states that wish to go after them. And that's part of the brutality and mess of this system that's about to be created by the Supreme, that we think is, I mean, I'm saying all this, it's possible the Chief Justice is working hard to get Kavanaugh or Barrett to move over to his side and to say, let's just say 15 weeks. And then we would have a more European system. 15 weeks, you can have your abortion, thereafter some exceptions and so on. And that's the rule and the states have to abide by it. I just am skeptical that that's happening. I mean, he may be trying, but I'm skeptical that that's going to happen. He brought it up in the oral arguments and nobody seemed to jump on it and say, yeah, that's a good idea. not even Barrett or Kavanaugh, are the more mild-mannered right-wingers on this right-wing clutch.
You're such a tease, Tom. I was feeling so good at the start of what you just said. And I maybe, no, it's great. And
I
we
don't
really
think
appreciate
they'll be able to stop abortions, but I think there'll be a lot of ugliness in, as there is now, in their stopping it, in their trying to stop it.
So this just occurred to me as you were saying this, and I could be going way out on a limb now, but birth control pills are just a step before abortion pills. I mean, can you make the argument?
That's right. They could go after those.
Okay.
Yeah, and somebody's saying here, is this a Nazi situation that we're looking at?
Yeah.
Well, you hesitate to throw that word around. But I would say that the point of intrusiveness and oppressiveness and Texas, that bounty rule where you get $10,000 for saying, that is just a recipe for hatred and betrayal in families, neighborhoods, professional settings. I hear my buddy Joe or my cousin drove his daughter to Oklahoma, et cetera, et cetera. I mean, there are a lot of, it's not just the Nazis who used a tattletale. The Cubans have used it. The French Revolution, that was tattling on people and getting them in trouble all the time. I mean, we use it, and it has its place in criminal law, but there's a lot of incitement to oppression in what's going on the right of American politics, and the court is abetting it, it seems to me, but bluntly and cynically.
So there's a question, could one argue successfully before the court that overruling the right to abortion is tantamount to imposing one religious viewpoint on the population at large? Wouldn't that be against the freedom of religion question?
And that's where I said earlier, it's embarrassing and even shameful to have an essentially all Catholic majority take over this question and decide it in a way that's in conformity with their childhood teachings, even if they've strayed a bit from the church in their adult lives and from the Catholic Church in their adult lives. Yes, it's a powerful, logical, and even philosophic argument. It's a powerful argument from the appearance of things. It's a losing argument, however, because there's always the possibility of saying, well, these guys say they hold these views on other grounds. And I know an atheist philosopher at the University of Chicago who holds these views. And therefore, do you see what I mean? It's not only a religious view. And science doesn't really enter into this because it's a moral judgment about, what's right and wrong. I mean, you can call it, when does life begin? But what they're really saying is, when do we care so much about whatever it is that's begun, call it what you will, that, fetus or not, that we're going to make criminal law attached to it and we're not going to let you harm it and so on.
This is a little, well, it may be outside of your expertise, but the question is, how do abortion laws compare in other countries? You touched on this a little bit, but abortion laws in Canada, Mexico, Australia, do you have some sense? I know you mentioned Germany, but.
There's a very good essay about Mexico. Was it an essay? No, a very good radio report, I think, but it might have been on the New York. Anyway, there was a very good report on a Mexican activist, I think in Guanajuato, who has pushed the medication. And this article in the New Yorker about Poland was talking about how I forget what it's called, but a feminist organization throughout Europe that has tried to be decentralized and provide pills and travel and other things, just the things that are going to happen in the United States if and when Roe and Wade is overturned. In general, the very few, we are going from a situation where we were the most liberal or among the most liberal about abortion under the aegis of Casey and so on, through constitutional rights protection, to a situation in which we may be among the most repressive, and certainly in the wealthier countries. That is to say, assuming that places like Oklahoma and Texas and Arkansas start pushing way back to concept that there's no constitutional right here and they push it back. As it has been observed by many, and I'm no expert, but I've already given a couple of instances, that Europe tends to have shorter permission. 12 weeks, 14 weeks, 16 weeks tend to be the typical pattern, not 23. And some people think that even in Catholic countries like Spain and Portugal and Italy, that has helped Europe avoid the terrible rivenness that we have in the United States in the politics around this issue. Others would say, and I think I'm more of this view, that America, for complex reasons that I don't think any of us fully understands, tends to have a lot of religious zealotry in our culture. And this produces, and has produced in the last generation or two, Falwell and all this zealous political movements taking over political parties. And then people like Trump, who obviously who have all the appearance of total cads who have no moral or religious views that would inhibit them in any of their pleasures at any time. But nonetheless, they buy into the religious view because that's the path to election and popularity and power. So I think I've answered that.
You have, and there were a few chat entries. Someone is offering that it was The Daily with Sabrina Tavernisi.
Yeah.
Okay, and then Dale says,
oh, the story. Okay, yeah, and she's great on the Daily, on the New York Times Daily podcast.
Right, and Dale says the New York Times Daily podcast yesterday had the deep dive into abortion in Mexico. And then Benita said, yeah, some traditional Catholic countries, Ireland, Spain, have laws much more lenient than ours.
Then ours, let's be clear,
okay.
then ours are about to become. Right now,
right, that's
it's
true.
hard to find a country that's more lenient than we are. But that's thanks to Roe and Wade and its upholding in Casey. But it's being, and I guess another point to be made in response is, yes, the chipping away in places like Louisiana and Texas and Arkansas and so on has led to situations where in theory you have a very generous right. In practice, it's damned hard to get an abortion. Travel, poverty, etc. All these things make it hard. And as I think everybody should know here, I mean, I'm saying what is obvious to those of you who are part of the gender studies group, you know, supposedly 60% of American abortions are women who already have family, already have children. This is not your 14-year-old girl, typically. That's a small percentage. There are definitely young kids who get pregnant. But a lot of this is people who are experienced and mature, but under tremendous duress, financially, in work, in raising other kids ahead of this one, this fetus.
Right. Okay, so with all the concern for the unborn, what about children who are born? No care is being provided for them. I think.
And there we can be clear that Europe is almost 100% ahead of us, right? I mean, it's
sure.
Some countries in Europe are poor. Look at Moldova and others, but almost every country in Europe makes an effort to have universal health care, really universal, not just Obamacare plus Medicare, but really universal. And I think most countries make an effort on leave, on promoting reproduction through family leave and so on making it easier for women to bear and participate in raising children with government help to the extent governments can give it. And a lot of those governments are much poorer than we are per capita.
There are two related questions here. How will preventing abortion for poor Black and brown women affect the demographic changes which are so feared by the white supremacists? And the related question in my mind is, how will this affect the economy when women will be forced to stay home to take care of an unborn child? So.
And Janet Yellen, you all saw, if you were listening to the radio, said this would have a huge effect on the economy. I didn't see the studies behind that, but I think she's great, and I trust a lot of her reports. And a sad part of this, I think it's sad. I mean, I don't mean to presume, but my understanding is that African American women have abortions at a rate something like 4 or 5 times the rate of white women.
I've heard that.
And as some kind of multiple over Latina women. And in other words, poverty hits so differentially and disadvantage hits so differentially in a society across with racial divisions like ours, that from a white supremacist point of view, there has always been a kind of perverse effect in this, because let's say a white supremacist says, like the handmaid, all the women should stay home and have kids all the time. It's still the case that when you prohibit abortion, you're supposedly, I mean, I don't know that this will be true, raising, I mean, I don't think they're going to, let me repeat my vote. I don't think this is going to be a successful policy. There are going to be more abortions, probably not less. A lot of them are going to get away with it illegally, quote unquote, in reactionary states. Others will have it in states that are liberal, because half the states will remain that way and become even more so.
And women will
But
die.
what will happen is there'll be brutal abortions and brutal deprivations, and then absurd, mean-spirited prosecutions, or there's just going to be a lot of ugliness here, and we can all watch. But the declining rate of abortion, which we've seen in the United States over the last 30 years or so, and certainly is, in my view, probably going to remain, about where it is, or, probably has reached a certain level. I don't think they're going to reduce the number of abortions by this.
Personally, I agree with you. I think it will just become more dangerous and more women will die. All right. So speaking of the Texas bounty law, can you explain why it appears no well-publicized case was actually brought to challenge it? So someone is sued under the law as long as Roe is the law. Would the case be appropriate for summary disposition because the federal law preempts any action under state law? I hope you understand that. Because
yes, and we were, most of us who are interested in constitutional law, whether lawyers or not, were shocked that the Supreme Court let this law in Texas stay. In other words, there wasn't an injunction against it or an interruption of its effect, and yet very little has happened. My understanding is there are some developing cases of people who are testing it, kind of like Dred Scott or plus, actual test case. But no, I have not seen, I don't know the answer to that in detail in Texas. And if Roe and Wade is overturned as I expect, will Texas stick with this bounty law, or will they simply go to a general? I don't know. There's an infectious quality to this bounty law on the right. And as you know, other states have been putting it in into their laws that are either proposed or even passed. I can't say what's going to happen there. It's another one of those very complex questions. But I tell you, we can all see it's trouble. Yeah. The idea of offering bounties to tattle on somebody about something they want to do that is part of their personal sense of themselves and their freedom and their control over their body and their sexuality, that's trouble. That spells super trouble. Just as much as some religion saying, I'll kill my daughter because she's marrying somebody of another faith or somebody who looks different or something, has caused terrible trouble in the societies where those kind of religious fundamentalisms obtain.
This is interesting. Won't this send the suburban white women running from the Republican fringe party? I don't see how the genie goes back in the bottle on this. So what's your thought on that? Will it send suburban white women running from the Republicans?
Let's hope so. It's some of the polling suggests that people are kind of if you're not, I mean, a lot of polling suggests it'll make a difference on the margin, but it won't make the huge difference we might hope it would make. In other words, really change the politics of the United States. But I think that's unpredictable. I think that's a thought. That person's question is really a good comment, and I don't know.
And someone is saying one cost you haven't mentioned is the rise of crime as correlated with the rise of unwanted births. Not sure.
Yeah, that's referring that. I don't know who is reading the University of Chicago stuff. The guys who do Freakonomics were involved in a famous study showing that, I mean, it's an awful thing to think that there had been a reduction in crime with more abortion because they were unwanted births, poor people, et cetera, et cetera. It was a very tough sociological kind of argument or hypothesis, obviously not entirely proven or not proven, but I don't know. Yeah, that's a cruel thought. Okay,
we're getting close to 4, but there's another question, and there were a couple actually on originalism. This one is originalism subject to the juris of a given court, or is there a standard agreed upon interpretation of the Constitution?
The answer to that is, again, somewhat complicated, but I think I can simplify it by saying this. I think it was Justice Kagan, former dean of Harvard Law School, who said, we're all originalists now. Don't kid me. Everybody starts with the original framing, and we're all textualists. Everybody starts with, what does the Constitution say about this? But then people say, what were they getting at? What was their overall hope and intent for this Constitution? What is the structure of the Constitution? What needs to be implied or understood? And I think that originalism is a label applied to one side of a debate to say, we know the truth and you guys are a bunch of fraudsters or fakers or whatever. And it's just it really is a fake. There is no way to have originalism is as loose, and the right-wing judges use it as loosely as any other label. Like, you know, sort of some, I mean, I don't mean to get too political here, but, you know, there are countries, I mean, maybe China is a great example, which say they're still communist countries, you know, when it's preposterous class and wealth differences in an essentially state, almost fascistic capitalist system or market system. It's that kind of label. It's a bogus label. Everybody agrees you start out in interpreting a law by saying, what does the law say? Any good lawyer or citizen says that. Next question, what is the law getting at here? How does it make sense to apply this law? And when it's a big question, like the role of the judiciary, what's needed to make this work? How is this practical? How can this adjust to modern life? I personally think, and I think most of us agree, that the gun rulings of the Supreme Court, while based on the Second Amendment, are completely cruel for a modern society with lots of people and lots of guns. It just leads to lots of murder and lots of suicide. And it's and some of it racist, and some of it you know, anti-woman, and some of it this and some of it that. But it's just not, you know, other modern societies don't have to put up with it. And I also think the history that led to the Heller decision was bogus history, bogus originalism. So I see it as a kind of a, you know, the guy sneaking up to you and say, hey, I got a great deal for you, this originalism, try it out. I think it's a trick. Even though I think there's a grain, like in so much, there's a portion of truth to it. Namely, you start with the text of the law as framed, as passed, and then say, now what can this mean as applied to this situation? So applied to COVID, the idea that the CDC can only tell you to wash your hands and not say put a mask on when you're in a close quarters like an airplane. Again, that one's subject to scientific review. If that didn't work at all, somebody might say, hey, this is an irrational law. But it's absurd for a federal judge to come in and say, oh yeah, just the only authority Congress meant to pass here was hand washing and cleaning off the trays, vacuuming the floor. You know, it obviously, we all know that we were washing broccoli a couple of years ago, and now we know that was a dumb thing to do.
Absolutely.
Unless we were snorting broccoli at the same time.
There are a number of additional comments. I was just looking to see if there are any questions. It's 3:53. Tom, I'm going to say, I know on behalf of Deborah and the entire gender shared interest group and all of the, well,
now we're down to 176. We lost 50 people.
Well, I have to say, it's probably, at least for those of us, it's a beautiful day in Massachusetts. And I know that some of your most ardent fans who have already contacted me today to say they love you and they're looking forward to the recording also said that for various reasons, they would not be able to attend today. So
wait, somebody has a question I do want to touch on.
Sure.
Did you say more white women have abortions than Black women? Answer, I didn't say it, but it's true, because there's a much larger group of Caucasian women than African-American women. What I said, just to repeat, was, and I'm not the sociologist who knows these studies well, but just reading in this area, there is a multiple of 4 or 5 times, I think, in the per capita number of abortions in the African-American population when compared to the Caucasian population. And those multiples shift with Latina and then obviously Asian and other, and depends on the subculture. But yes, Black women are having abortions. I'm sure it has to do with poverty and difficulty and challenges and stresses in life, ultimately with racist wounds and harms in their lives. But they are. And so it's an odd thing for a white supremacist to say, I want no abortions. I mean, I don't even like to think that way, but it's true that It in theory would mean many more births among the poor, and the poor are disproportionately unable to travel and unable to afford to do these things.
Right.
And also,
And
so
take
anyway,
the ball.
are
Sure.
we wrapping up then or not? I
think
just
so.
saw that one and I didn't want to let it go because
No, I appreciate that. And I'm going to apologize to everyone who has sent in a remark that I may have.
That's an interesting chat when I look at it.
It's a very interesting
My
chat,
friend
and
Dale here is hammering away on it.
I promise that I've done my best, everyone, to get to your questions, but if I've missed anyone, again, I'm apologizing in advance. People are saying what a wonderful job you did, Tom, and of course you did.
Yeah, it's a sad discussion.
Well, but a necessary one, and you are the expert, and we very much appreciate your taking the time to speak to us.
Well, don't get me wrong. There are a lot of greater experts like Linda Greenhouse, who spends a lot of her time in Stockbridge. So yeah, there are more important people to listen to, but I'm a local guy who tried to help on this.
So I'll tell you what, before we close out, can you give me and the rest of us something hopeful to look forward to? You have, but send us out on a happy note.
I mean, as with guns, I think we should, despite Buffalo, most of us here are in New York and Massachusetts, two of the most liberal states, the most caring states in formal policy terms in the country in these regards. And there are lots of other states like us, and there are like lots of other states very, very different. But I am hopeful that this will not stand, but it may take many years. I am hopeful that American democracy will become a real democracy. That will definitely take some decades. It cannot really go on like this, in my view. That is to say, a minority with permitting lots of money to be spent on political campaigns. So in effect, they're bought. I just think this is not the way democracy can work, and abortion, reproduction and sexual choice cannot work this way with states intruding on women. Talk about equal protection. This is really going to be a blow to that womanly part of our society that can't afford to evade it, doesn't live in New York or California or something. So I'm hopeful, though, that the liberal side of this equation is the popular side, the greater part of the populace. And eventually American democracy is going to have to yield to true majority rule, but it's going to take time.
Well,
so work at it.
Yeah, I guess that's the point. And people were asking what else we could do besides march and write letters and so on. And I guess it comes back to what we said.
And
we
vote and run and campaign,
exactly.
and support those who do. If you can't do it, and so on.
Right. So
okay, well,
we are pretty much there. Tom, it's
okay,
been
thank
great.
you so much. I'm almost lost.
Thank
All right.
you. We appreciate it. Thank you,
All right,
everybody.